Thank you, loyal blog readers, for joining us on our next episode of our weekly podcast series, the Class Action Weekly Wire. I'm Jerry Maatman, a partner at Duane Morris, and joining me today is Brandon Spurlock. Thanks so much for being here on our podcast.
Great to be here, Jerry.
Today, we wanted to discuss trends and important developments with procedural issues in class action litigation. This is somewhat of a catch-all term in the Duane Morris Class Action Review in terms of our analysis of key rulings throughout the year. In 2023, federal and state courts addressed procedural issues on a wide range of class certification issues. Brandon, to your way of thinking, were there some highlights that corporate counsel should be aware of?
Yes, jurisdiction is always an important consideration. Class action litigation. Jurisdictional defenses are often dispositive when a defendant challenges the ability of plaintiffs to maintain their class action in court. The 10th Circuit issued a very interesting ruling on jurisdiction in Bolter versus Noble Energy. There, the plaintiffs, a group of oil and gas lessors, filed a class action against the defendants for alleged underpaid royalties. The defendants then argued that the district court lacked jurisdiction because the plaintiffs failed to exhaust administrative remedies required by Colorado's Oil and Gas Conservation Act, which grants jurisdiction to the COGCC to determine the amount of proceeds due to a payee. However, the act excludes resolution of disputes over contract interpretation from the COGCC's jurisdiction. The district court then agreed with the defendants and granted their motion to dismiss. The plaintiffs did not appeal this decision, but filed a nearly identical second complaint in Bolter 2 3 months later. While the second complaint was pending, the Colorado Court of Appeals issued a decision regarding the COGCC's jurisdiction in another action. The district court dismissed Bolter 2 for the second time, and plaintiffs filed a third complaint, Bolter 3, December 2021. District court again dismissed the action. On plaintiff's appeal, the 10th Circuit affirmed the district court's ruling. 10th Circuit considered whether the district court's decision in Bolter 1 to preclude the jurisdictional arguments in Bolter 2 and Bolter 3, and whether an exception to issue preclusion based on an intervening change in the law applied. The 10th Circuit concluded that the ruling in Bolter 1 did preclude the jurisdictional arguments in the subsequent complaints. The 10th Circuit also determined that the decision from the Colorado Court of Appeals did not change the law or provide a basis for plaintiffs to avoid exhausting their remedies with the COGCC. Therefore, the 10th Circuit affirmed the district court's dismissal for lack of jurisdiction.
I always found jurisdiction to be a very powerful argument for the defense in a Rule 23 situation, but equally pertinent is the concept of standing and whether or not a named plaintiff has standing to prosecute a class action. In 2023, however, the plaintiff's bar secured a pretty plaintiff-friendly ruling on the issue of standing out of the 9th Circuit in a case called Vargas versus Facebook. The district court had dismissed the named plaintiff's claim in a class action for lack of standing, where the named plaintiff, a New York resident and a Facebook user, claimed that as a member of a protected category group, she was unable to view housing ads that similarly situated white Facebook users were able to access based on the algorithms at issue in the Facebook platform. On appeal, the 9th Circuit reversed the dismissal of the class action and remanded the district court's ruling. The 9th Circuit held that sufficient allegations were asserted in the complaint with respect to the disparate treatment of the named plaintiff as compared to white users of Facebook. And as a result, there was a viable cause of action and an injury in fact sufficient to confer standing. Many legal commentators think that the Vargas decision is kind of on the outer edge of standing principles, but nonetheless shows in a very plaintiff-centric or plaintiff-friendly way how standing can exist in a class action complaint sufficient for the class action to go forward. Brandon, are there other areas that you think are impacted that is favorable either to the defense bar or to the plaintiff's bar in the class action space?
Yes, Jerry. I also wanted to address the issue of consolidation in class action litigation, since consolidation issues often surface when defendants are subject to multiple class actions, and whether or not to consolidate multiple cases in one form is often a strategic imperative. For instance, in the case of TikTok in that browser consumer privacy litigation, the plaintiffs filed multiple class actions alleging that TikTok illegally intercepted users' communications and activities on third-party websites through the web browser within the TikTok app. The plaintiff in the class action, which is pending in the U.S. District Court for the Central District of California, moved under 28 U.S.C. Section 1407 to centralize 3 of the actions in the Central District of California. Since filing the motion, the Judicial Panel on Multi-District Litigation, the JPML, have been notified of 14 potentially related actions pending in 3 additional districts. All of the plaintiffs supported centralization, but the plaintiffs in 5 actions supported the movement's position. So while the plaintiffs in 7 actions requested centralization in the Northern District of Illinois, and the plaintiff in 1 related action alternatively requested centralization in the District of New Jersey and also the Northern District of Georgia, and 1 plaintiff opposed centralization entirely. Because the in-app browser actions raised questions relating to the interpretation and the scope of settlement and the related MDL, the JPML ruled that those questions would be most appropriately resolved by the transferee court. Therefore, it denied the motion to centralize those actions.
I always thought consolidation of multiple class actions in one court or centralization of consolidated class actions is a big money saver for the defense in terms of defending something once rather than multiple times. So that's a key ruling. What about the area of sanctions in class action litigation? Were there any particular rulings of note in 2023?
Another good question, Jerry. Given the cost of defending a class action, corporate defendants sometimes move for sanctions if the claims are frivolous. For instance, the Sixth Circuit examined this issue in Garcia versus Title Check LLC. There, the plaintiff filed a class action against the defendant, alleging that its additional buyer's fee violated Michigan's General Property Tax Act. The district court dismissed the plaintiff's claims, finding that the fee was not prohibited by statute. Subsequently, the defendant moved for sanction against plaintiff's attorneys on the grounds that the case was frivolous and forced the defendant to incur unnecessary legal fees. District court granted the motion and ordered plaintiff's counsel to pay attorney's fees and costs over $73,000. On appeal, the Sixth Circuit has affirmed the district court's ruling. Plaintiff's counsel argued that the district court erred in opposing sanctions because the legal issues in the case were debatable and because the district court misunderstood Michigan law. Sixth Circuit agreed with the district court's conclusion, however, that plaintiff's counsel had unreasonably pursued frivolous claims based on an implausible interpretation of the statute. Sixth Circuit also found that the plaintiff's counsel should have known their claims lacked merit. Sixth Circuit further rejected the argument of plaintiff's counsel that sanctions should have been limited to the specific filings related to the unnecessarily claims. Instead, it deemed the entire action frivolous and vexatious and affirmed the district court's ruling. So, very powerful use of sanctions that supported defendant's position in that case.
Those are great insights and analysis, Brandon. It certainly underscores the notion that non-merits issues, in essence, procedural issues, can be important to the overall outcome of a class action and the method by which a corporation defends itself in class action litigation. Well, loyal blog readers, thanks so much for joining us in this weekly installment of the Class Action Wire, and thank you, Brandon, for providing your thought leadership in this space.
Thanks for having me, Jerry.